During questioning, several interesting arguments were looked at. Let's start with whether or not a subpoena is a command or merely a request.
Your argument seems to be based on the mere reception of the subpoena. So what did that cause you to do?
Sure. So under the Article 3, we can have both a present and a future imminent harm, Your Honor.
But what did you have to do upon reception of the subpoena?
So the subpoena commands First Choice to do several things. It commands it to produce 28 different categories of documents, including every solicitation, email, and text message it sent to its donors. It commands it produce donor names, addresses, phone numbers, as well as places of employment. It imposes a litigation hold, Your Honor, and it also chilled First Choice and its donors' First Amendment rights.
As I pointed out, this subpoena cannot violate the First Amendment since it's not based on the law made by Congress. However, by compelling that First Choice do something, the Attorney General deprived them of their liberty to privately communicate with their donors. That violates the 14th Amendment's Due Process Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law. Remember, under the Fourth Amendment, any search must be reasonable. Now, there are circumstances where a search can be reasonable without a warrant. There has to be some basis for reasonableness.
Were there complaints against you that stimulated the subpoena?
No, Your Honor. The Attorney General has never identified a single complaint against First Choice.
If there's no complaint, what is the reasonable articulable suspicion that a crime has been committed? There isn't one. So what makes the search of documents a subpoena is demanding reasonable? But is a subpoena nothing more than a request?
Did you view this as a request? The briefs of the Attorney General seem to suggest that this is, I've never heard the term subpoena request, but did you view this as a request?
Absolutely not, Your Honor. This is not in the record, but First Choice immediately convened an emergency board meeting to discuss the subpoena. The very Latin term for subpoena means under penalty. If you look at the face of the subpoena, it twice commands First Choice to produce on pain of contempt, and it twice threatens that the failure to comply with this subpoena, not a later state court order, but with the subpoena, shall render First Choice liable for contempt and other penalties at law. Some of those other penalties at law are business dissolution. That is a death knell for nonprofits like First Choice.
Having received a federal subpoena, I can tell you there is nothing about that process that leads you to believe it is a request. Now that I know that a subpoena is Latin for under penalty, I'm sure it's not a request. During questioning of the respondent's attorney, Justice Thomas asked the same question.
What is the difference between this subpoena and a request?
Your Honor, this subpoena is a predicate under state law for the state executive branch to be able to go to a court to seek a court order requiring production. We couldn't do that if we had just sent a letter request. But in other critical respects, there's really not a difference in terms of the legal obligations that are actually imposed upon a recipient of a subpoena.
Funny, when a district attorney seeks a court order to compel attendance, I don't think they issue a subpoena first. Does law enforcement, part of the executive branch, seek a subpoena before seeking a warrant? Mr. Iyer went on.
Typically, when we think about subpoenas, we're thinking about grand jury subpoenas or subpoenas that are issued by a court during civil litigation. I think an administrative subpoena is very different, and courts, as a matter of state law, have held across the country that these subpoenas themselves don't impose any obligation to produce documents from the moment of the issuance.
So a document, literally titled under penalty, does not impose an obligation to produce documents under some penalty? Does that sound reasonable to you? If there is no obligation, then why does the subpoena use the term compel? Justice Gorsuch also asked about the power of subpoenas.
And just looking at the statute, it says the AG subpoenas have the force of law. And if a person fails to obey the subpoena, the AG may apply to the Superior Court and obtain an order adjudging such person in contempt of court. Now, I don't know how to read that other than it's pretty self-executing to me, counsel. Now, I maybe that's anomalous. Maybe that's wrong. Maybe the New Jersey Supreme Court's read it differently, but that's not the materials I have before me, so help me out.
Absolutely. So we think there are a number of reasons why these subpoenas need to be understood as non-self-executing.
The state of New Jersey claims that a subpoena is not self-executing, meaning someone cannot be held for violating it. But state law says a subpoena from the Attorney General's office has the force of law. So which is it?
Ms. Crowley, I'm sympathetic to the argument that the subpoena on its face looked like it carried penalties based on everything that you said. But I think we have to accept for purposes of this case that it's non-self-executing, and so that it did not, in fact, at the moment of receipt, demand that you reply on pain of contempt to send you a subpoena that will demand all of these documents, or just a letter requesting them that wasn't a subpoena. Please turn over to me all of these documents. Would a letter have been sufficient then for ripeness under your theory? What if he had just sent a letter saying, I intend to send you a subpoena that will demand all of these documents, or just a letter requesting them that wasn't a subpoena? Please turn over to me all of these documents.
Think about that for a second. A letter stating you're going to be sent a subpoena to demand documents that aren't really a demand because the subpoena is not self-executing and requires a court order to be legally enforceable. Does that make sense to you? Besides, the AG didn't send a letter. They sent a subpoena that stated, you are hereby commanded to produce to the New Jersey Division of Consumer Affairs, Office of Consumer Protection, through Chanel Van Dyke, Deputy Attorney General, at 124 Hazley Street, 5th floor, Newark, New Jersey, on or before December 15, 2023 at 10 a.m. the following. Does that sound like a non-self-executing request that needs a court order to be enforced? No, it sounds like a demand to produce documents to be searched without a warrant, exigent circumstances, or even a reasonable cause. That, ladies and gentlemen, is an obvious and blatant violation of the Fourth Amendment.